Hello, this is another edition of Naavi Academy. Today is 21st March 2025, and I would like to share some thoughts on a petition which has been filed by X, the platform, which was earlier called Twitter, in the Bangalore High Court, which has been extensively reported by the media since yesterday. There have been many TV debates also on the topic. Essentially, the media highlighted as if Mr. Elon Musk, a friend of Donald Trump, and therefore a friend of Narendra Modi and India, had betrayed the trust by filing a case against the government of India, opposing removal of some content which was held as offensive from the national security interests. However, if we go through the petition in detail, filed by a well-known law firm in Bangalore, it is clear that the petition tries to educate the government of India about how to use or how not to use Section 79 of Information Technology Act as an instrument for blocking of content on internet. The petition itself indicates that there is Section 69 capital A, which is meant for a similar purpose, and it ought to have been used in a case like this where the government really wants to block a content on internet. But invoking Section 69 capital A requires following of a certain process, including a meeting of the committee involving the Ministry of Home Affairs, and then the ruling should be handed over to the Ministry of Information Technology, which should pass it on to a platform like Twitter or X. What has happened in this particular case is that the Ministry of Information Technology has used the intermediary guidelines provision, and through that has invoked a provision where they have appointed certain agencies as nodal agencies, which was a concept which was there in Section 69 capital A, not under Section 79. And the Ministry of Railways was appointed as a certain nodal agency, and it used its status as a nodal agency to send a notice to X with a list of posts which must be deleted. The language used in the notice was to actually mandate deletion within 36 hours, instead of just alerting them that the information is false and therefore it will make the platform ineligible for Section 79 protection. It is therefore suggested that the government does not stand on prestige and instead withdraws its notices, issues modified notices as required under Section 79 and or Section 69 capital A. And thereafter, the court can allow the petitioner also to withdraw the petition itself. Assuming that both parties stand on their prestige and continue their trial, it is possible for the court to adjudicate on whether Twitter or X is in fact an intermediary under Information Technology Act and whether it is eligible for any protection at all. The definition of intermediary is very clear that any platform which consumes the information from the third parties, uses it for advertising, filters it, modifies it, and curtails it, and in some way exercises control on what ultimately goes for publication on the platform will not be considered as an intermediary. It applies not only to X, but also to all other platforms where the current trend is to use some kind of artificial intelligence to analyze the data and use it for their data analytics purpose. Therefore, if the court really takes it seriously, it can confirm through their judgment that X is not an intermediary. And that will be a backlash on the petitioner, perhaps unintended. At the same time, I would also like to say that if we go back to the infamous Shreya Singhal case, I call it infamous because this judgment came up on the premise that posting a message on a Facebook platform or a Twitter is not considered as publishing under Section 67 and other sections of Information Technology Act. Rather, it was considered as a message under Section 66 capital A of Information Technology Act. This misunderstanding by the Supreme Court led to the scrapping of Section 66 capital A, which was applicable for messaging like an SMS, like a WhatsApp, and not for publishing of information like on a website, like on a Twitter platform, like on a Facebook platform. This wrong interpretation by Supreme Court resulted in Section 66 capital A being removed, and along with it, a law which could have been applied for spamming also was removed. I hope that in the current case, the courts do not rule that Section 79 subsection 3 is affecting the freedom of expression and therefore needs to be scrapped. It is easy for the court to take a TRP view and then come to that conclusion, and all the media will perhaps appreciate it. But the court should remember that if laws are made, but we cannot understand or properly interpret the law, then the fault lies with the interpreter and not with the law. And if there is really a need for providing clarification on the law, there is always a provision of reading down a provision on the law, which was not used by Supreme Court in the Shreya Singhal case. And we should perhaps request the Karnataka High Court to remember that it has this provision if it feels that Section 79 capital 3, Section 79 subsection 3 needs some clarification. They can always provide a reading down, but not go to the extent of scrapping of the law. So this is my simple observation, but I must end this by thanking the petitioner for bringing this up for public debate, because 25 years since Information Technology Act, and perhaps since 2009 when Section 79 was amended and Section 66 capital A was introduced, the government still does not seem to fully understand the ITA 2000. Of course, we cannot hold the executives in the ministry responsible for this because they need to be advised by the legal counsel which is available in Delhi, and perhaps they need to change their team of advisors. Thank you for listening, and if you are having any comments, you are welcome to provide it. Thank you.